that everyone understands is going to be the next effort at establishing what are the rules in place on the boardwalk. And that's going to be a process. It's going to be frustrating for everyone until that gets done. So here's my view. The council member is very upset, but being upset won't get us to the solution. So all that does is energy, and it's important energy because we all want to please the goal. But I got involved in this. You know, I've seen now 3 iterations of the 4215. I mean, 3 different versions have been enacted. And none of them has held up. And we've relied on the advice of our city attorney's office, and with all due respect, you know, they've done their best. But First Amendment law is extremely complicated. So I've watched all this. I'll be frank with you, it's been an interesting education, but I have not seen any answers yet. So I will be candid. The councilman has asked me to take a more active role than in the prior drafting of the ordinance. So here's what we have learned about our ordinance in the last several months. We've had 2 decisions. One was an injunction, or an order for an injunction more accurately, made by our local district court judge, Dean Craves, which said your amplified sound ban is unconstitutional. And in essence, what he said is, I'm sorry, I know I helped put it in place, but now the Ninth Circuit made a decision in Berger, and your lottery and your permit system that is part of that are a prior restraint. It's an unconstitutional system for space allocation. So let's talk practically here. Is that me? Is that you?
I think it's you.
Oh, okay, well, ignore it.
Should I send a reminder now when you walk in, make sure phones are on?
Okay, so the most important thing we'll need from the community, because the community knows best how the boardwalk operates, is in essence a space allocation system. What the court said was first come, first served for now, and you can come back with a space allocation system, but in essence, I don't know what that would be. So we haven't got any help from the court, and I'm talking to federal district court on that, but saying, hey, we're open to ideas. So what we got is first come, first served by default. All right. There's been a second very important decision, I think far more important decision, and that is by the Ninth Circuit on March 22nd. And that decision was in the case of Hunt. It's Hunt down, but it's the lead plaintiff is Hunt, Michael Hunt, versus the city of Los Angeles. That decision was rather significant in 2 respects. Number one, since I've been watching this, in 2004, the standard was something called inextricably intertwined. If anyone can explain that to me, please do. The second one is something called basically, well, I can tell you actually what inextricably intertwined means, but it would be a legal discussion. I can tell you what the Gotti case said. 2006, which is the San Francisco decision, we had a standard that was put into place that said, in essence, you can sell expressive stuff, and if there is a value to it that is beyond nominal for what is not part of the expressive, then no can do here on the boardwalk. And it listed items are deemed accepted, essentially expressive, and it listed items that are not deemed expressive. Well, when I came into the picture, there had been a lawsuit pending, a different lawsuit. It was Food Not Bombs, although Hunt and Dowd were part of that too. And it was a challenge to the 2006 4215, it was as I just described. And that I was asked to come to court when that was pending, and I did so. And there was basically a year of going to court where this new 2008 ordinance was essentially created to settle that lawsuit. And the city attorney at that time opined that they believed the 2006 ordinance would not withstand a challenge to the Constitution. So it kind of never really got evaluated in that proceeding. However, what the district court did do, ultimately, in a case involving that issue, is it allowed Michael Hunt to go to trial. And those of you, that's the case that is now, I'm going to talk about, that was just decided. In that case, the trial judge, Dean Pragerson, did two things. He said, inextricably intertwined is vague. And you may go to trial on that, Mr. Hunt. However, on the 2006 attack you've made, you cannot go to trial. And Mr. Dowd, you cannot go to trial because, Mr. Hunt, your sale of shea butter, no matter how you describe it as being connected to an African religion, you're there to make money. It's a commercial activity. It isn't expressive activity. And he said, Mr. Dowd, even though your incense is handmade and you attributed all these characteristics to it, I'm sorry, incense is not inherently expressive, and you cannot go to trial on that as a trialable issue as a challenge in 2006. So, that is the case. Now, Hunt, as you know, went to trial. He received a jury verdict, and that case went up to the Ninth Circuit. That's the case that was just decided. And what they decided was that Mr. Pragerson, Judge Pragerson, was correct that the 2004 version of the ordinance, based on inextricably intertwined, was, I think their language was, is the ordinary person could not possibly understand what was prohibited or what was allowed. They wouldn't be able to know. And he said, and you know, we're studying it up here with our law books and we can't figure it out. So therefore it is unconstitutional. However, we agree with Pragerson that the 2006 version, which by the way, the city had walked away from without ever really testing it, is constitutional. And you have, and looked at it, it looked at four things. Number one, it says it's not vague. Number two, your time, place, and manner rules are valid. Number three, the big issue is prior restraint. In that case, each of these people who were challenging it had permits, so he said no prior restraint because they hadn't been denied the participation. And there was a fourth issue, which now escapes me. But the core points I've articulated. So now we've learned that any permit system is probably going to be a prior restraint. So we're going to need something that is not involving a permit system. And it probably doesn't involve a lottery either. So that's what we have to figure out. However, it seems like we could simply go back to the 2006 version, which was upheld in terms of a standard. Is it expressive? And is anything other than the message of basically nominal value? In other words, the value of what is going on here is the expressive item. And yes, it could be vended. You could sell newspapers. You could sell certain things that you have prepared yourself. You could prepare certain other things that you as an advocacy group are promoting that's clearly protected by the First Amendment. It did specify some things that I think would be most interest to the merchants here, which you could not sell. So you can go and walk up and down the boardwalk yourself and determine whether there are people that could no longer be there under this standard. The prohibited items were sale of houseware, appliances, articles of clothing, sunglasses, auto parts, oils, incense, perfume, lotions, candles, jewelry, toys, and stuffed animals. Now, that list is not, yeah, you could have other items, there's other language that describes what you can't do. But we can't have the police, we can't have rec and parks deciding what is or is not protected speech. Right. We are not going to have an ordinance this time under the leadership of Councilman Rosendahl where we ask them to do that. That won't work. So we need to figure out a way of saying in an understandable way, this is permitted, this is not permitted. And that's the current effort, is to figure that out. So, look, the experts on this in our city attorney's office are no longer engaged in the process. So there is a void there. So one thing that I have done at the request of Councilman Bill Rosendahl is I have reached outside of our city to seek some counsel among people that I happen to know from my prior life, who happen to be real First Amendment lawyers. And I sent them these decisions and our ordinance, and I've said, what can we do? And what can't we do? Give me a roadmap. And I'm trying to then bring that to the attention of the people who will draft this so that they can evaluate. There's many lawyers inside the city who have, views that they understand the First Amendment. The first thing I always learned in my life is know what you don't know. And I find the First Amendment to be a very challenging area of law. I've done a lot of work in the last few weeks, so at least I can ask the right questions. But I do not presume to have any of the answers. Now, the one question I'll just throw out here right now is, so people are going to say, well, what about the Gotti case, which this lady is bringing up? And in the Gotti case, I just want to be clear about what happened in that case. So I don't want to get too legal, but I think this is something that is so confusing that I'm just going to give you my simple, understanding of that case. What happened in Gotti is there was a regulation in San Francisco that wanted to keep certain people out of Fisherman's Wharf. They wanted Fisherman's Wharf to have a certain ambience appearance. So they said, hey, you can't hawk stuff here, basically. Okay? You gotta have a permit. And that was what Gotti said, no, you can't stop these 5 groups. They were all non-profits. One of them was a Indian religious group. Clearly, it was proselytizing for its religion. It was sending out literature, buttons, and all kinds of stuff. Another group was Greenpeace. Greenpeace. I don't think I have to explain what Greenpeace is to anyone here. It's a very vigorous environmental organization. Another group was it was actually organized to oppose American foreign policy in El Salvador. All right? Another group was a nuclear freeze group. And the 5th group, I'll forget it again, but it was unquestionably all advocacy groups. They were all official nonprofits. And the court says, hey, you can give out, you can sell your literature, you can sell your stuff, and you can sell your T-shirts that say "Stop War" or free somebody or something like that. And if you have jewelry that has these messages on it, you can sell that. Because what we see you doing is primarily dominated by what is protected speech, pure speech. And these things that would be commercial speech, and we recognize they're commercial, are essentially de minimis. They are insignificant in the context of what you're doing, therefore you can allow it. And that's where the phrase inextricably intertwined came to be. It meant that these things that you could normally, it would be just be commercial speech that doesn't have the same high protection, you couldn't do you could do when your dominant activity was so clearly protected speech. Then here in our great boardwalk, we had two people that you would all recognize. Robert Newman, otherwise known as Jingles, and Harry Perry, otherwise known as Harry Perry, brought a lawsuit saying, hey, wait a second. You can't limit it to nonprofits. I'm an animal. I fight for animal, from people abusing animals and eating animals, and that's what I'm about. And if I want to sell my T-shirts plus all my other literature, I'm clearly just like those people in the Gaudia case. And the fact that I choose not to organize as a nonprofit, hey, it's no difference. And Harry Perry says, hey, I'm a musician. What I do is all protected too. It's clearly expressive, and so I sing religious songs and things like that. But I'm a musician. That's clearly protected speech. And the court said, you know what? You're absolutely right. You don't have to go and apply to be, get a legal document that says you're nonprofit. But it didn't change anything about the court decision. The Gaudia standard of inextricably. Now, it took me a while to understand, to be quite honest with you, and inextricably intertwined pretty much confused me. But to be honest with you, I think a lot of people were confused about what it meant, and it's very hard to describe what it means in a simple way. That took me a lot of time. So I don't know what words we can put on a sign other than that still would say you can't sell jewelry and you can't sell articles of clothing, which would be two things that would be allowed under this thing. I don't know how to say it. I really don't know how to say it. I'm going to try to get a very famous First Amendment lawyer, I won't mention their name, but a very, very well-known lawyer, if I can get that person to review it and just tell us if we're right on the law. Now, let's be clear about this. You guys want to see a draft, and you want to give input. With all due respect to everybody, this is essentially a legal thing. The city, which has had real problems with this, is going to need to do the lawyering. It needs to do the lawyering, and then it needs to put a document out there. And if you want to come and say, hey, I don't know what the heck that means, or that's wrong, or here's a way to do the space allocation, that's where you can really contribute. But frankly, we can't pass the buck as a city and say, let's all come together in a room and reason together and decide what's legal. Frankly, that's not the way it works. It would be just completely false to say that. We will, meaning the City of Los Angeles, meaning the City Attorney's Office, will draft the ordinance. I'm not going to be the one that makes that final decision. I do have a legal background. I will share my thoughts. Yes, the lawyers do talk to me there. Yes, we have meetings. But ultimately, they make the legal advice that goes to the government, and that's the City Council. And the City Council, when they have a closed session and approve, or open session and approve an ordinance, it is the city attorney that is sitting up there at the table giving the advice to the council. And that's the office we will ultimately have to convince how the ordinance looks, and they will have to draft it. And I don't know what else to say. That's where it is. That's the process. That's the state of affairs. And I'll answer any questions. Doesn't mean we are there. It doesn't mean the city attorney will agree. But that's what our Ninth Circuit just told us is legal.
Now, what has happened in the past when an ordinance has been drafted is there's been a big disparity between what the ordinance is, how it is enforced, and management of the boardwalk. Because management of the boardwalk has been the absent part of what's been happening on the boardwalk. There has been no management. It's been left up to the Department of Rec and Parks or the police, who shouldn't be managing an expressive zone. So any ordinance that's drafted should include and be in accordance with a system of management, so that you don't have that gap that has existed in years past.
Thank you.
Stephen, I'd be happy to discuss that with you privately. My view is not necessarily dissimilar to your view, okay? But that and a buck will buy you a cup of coffee. You know, it's a huge problem in terms of we have very conscientious management in place here from Rec and Parks. But Rec and Parks, generally speaking, historically, you know, the people that are here, they are people that are highly qualified to run programs. And if you look at our rec center and you see the operations of our, you know, facilities there where there are programs, they're doing a great job. The boardwalk is a very special case, and I agree with you that it needs very special management that is not currently, you know, it's way, you know, way different than running the kind of programs that are generally part of Rec and Parks. I will say that Rec and Parks has found a way to address special management problems in other special locations, like the Expo pool situation at the Coliseum and like Griffith Park. But they have not yet concentrated on such administrative strategies in this park that they manage.
Sherman Trust Act would be in support of getting rid of the commercial vending off the boardwalk. I don't know if I said it wrong for it not to be understood.
Well, let me answer the question just simply put. In our existing ordinance in the preamble, it talks about, I'm going to use a clearer phrase than antitrust, it talks about unfair competition.
Right.
And the courts have made it clear that that is a legitimate government interest for the city of Los Angeles to draft an ordinance that is designed to protect the merchants against unfair competition. The problem the city has had in the past is that it has not come up with a system that also recognizes that Venice Beach is a public forum entitled to the highest level of protection for First Amendment activity.
Right.
And they have not been able to reconcile how to do those two things. Maybe this time we'll get it right.
Okay, and my question is, the big meeting that I organized a couple of years ago at the dog park that you attended, you talked a little bit to me about the city having the right for the zoning, and you came up with the I and the P zone.
I didn't come up with the I and P
No,
zone.
well, not you.
Not me.
Not you.
That was the idea of Dean Pragerson, and I'll make it absolutely clear that I think that is not an idea that should survive the next iteration.
I worded that wrong, but my question is, now, if the city, what I want to know is, does the city have the right to continue with the zoning of spaces? Because I have a suggestion if it does.
Well, we would be most welcome to all suggestions, because basically they're going to, presumably that we will, to keep order, still have some designated space system. I believe there are now 204 or 205 spaces. They're divided up between the I and the P zone. It's not my decision, but certainly would be my recommendation that there would not be in the next ordinance, assuming if there were 205 spaces still, an I zone and a P zone.
Okay.
Thank you. I need to move on to some other questions.
Can I finish my
We've got,
suggestion?
hold on for a second.
Because I tried to give this last time and you called Marie instead of calling me, so
Here's what I'd like to suggest, because it's already 11:15.
it's very quick.
I want to be sensitive to some of these folks that have questions that don't usually come and hardly have the opportunity to ask questions. So let's finish up the meeting here. Let's finish up the meeting here. Norman's going to be here for a few more minutes afterwards, so he'll be more than happy to have a one-on-one with you. But let me go over here, and then we'll call the meeting. I know I saw a hand over here.
Yes, sir.
What about my hand? Go for it.
Is the ordinance, is there any ordinance still in place? By any chance?
The answer is yes. There are a whole host of provisions in the ordinance that are still valid, good law, but we have the practical situation is the city attorney has advised the LAPD that they can enforce it until there's adequate notice. And the problem is there's no adequate notice because nobody knows what to put on the notices. Okay, so we're in a, what do you want to call it, a twilight zone.
Yeah, we'll hold it, a vortex.
Excuse me, selective enforcement. If you don't allow me to speak, I'm going to sue the Bill Rosenthal's office as selective enforcement. You let everybody speak. Ground X says that you talk and I have a right to reply.
Hang on for a second. It's
It's
now.
not a Brown Act meeting.
Oh, yes, it is, baby.
No, it's not.
It's now at 11:15. If folks have some final general questions
Yes,
for the
I do.
group, let's go ahead and finish up with these last two. And then I know Norman's going to be here for another 10 minutes, but then he's got to get out of here at 11:30. So he'll stick around for some additional questions or
Excuse me, I
comments.
had my hand up for a
But
long
let's
time.
go to Joel, and then we'll go to Marie's final comment, because I'm sure we'll have to weed through the questions. Weed to find the questions.
Thank you for explaining everything and for all of your work on this. I'm wondering if you can just give us any kind of overview on what might be taking shape as far as space allocation. Is there anything at all you can share with how that piece might work out?
That canvas needs to be painted. At this
Okay.
point, I've listened to an awful lot of ideas where people have tried very, very hard to, come up with all these different proposals, but they're not practical. None of them will work. And that's the one thing that seems to have been the theme for many years on the boardwalk, is people like to use pretty words, but nobody can understand them, or it calls upon the everyday people that have to administer it to do things that they're really
That camera's
not in a
following my
position to do. So all I've heard that's made any sense, frankly, was not a whole lot different than what someone said earlier, is to get people to line up on the beach side of Oceanfront Walk, rather than on the east side before the first come, first served. That's about all I've heard that anyone seems to coalesce around as a sensible way. But every other kind of system where they talk about, coming for a, even if no one has to write their name down, some kind of, thing that identifies a space as theirs for the day, or, you line up in a certain order, or all those kinds of things don't seem to be getting any traction. So we invite ideas, we really do.
You guys are very smart, and you have been down this road for a long time, and I know that you're doing your best, and if there was an idea, you would put it out there, but I just wondered if there was a workable idea. It doesn't sound like there is right now.
Yeah. Thank you.